Sorry.
One restoration, same appeal.
Same appeal for restoration.
Yes.
This got them at
Whenever,
this bench.
whenever your lordship.
But see, no, sorry. Same appeal has been changed. Same appeal has to go to assigned bench. I think since March or April, there is a notification. What is that called? What should I call it? To the cycle?
Then it has to go to the Hon'Ble Chief Justice. Because
you move the deputy register.
And it has to be referred.
Only review, I think review only remains with the. Even contempt, there is no notification.
No, contempt is not.
I think contempt also has to go to the assigned bench. I'm not very sure, but same appeal, I'm sure. Same appeal is no more to be for restoration. It has to go to the regular bench. This difficulty of handing up bench is no more there.
No, this matter cannot be listed before also the regular bench.
I mean,
Because they have to come.
it has to be assigned by the Honorable Chief Justice. You they do. Sir ko de diyo.
Item 5 adjournment on behalf of the Keponda.
Your name, sir, Mr. Nath.
Yes, sir. Yes, sir. Yes. On
S. K.
behalf.
Nath. Adjourned with liberty.
Yes, sir.
Yes.
Also, item 6 also adjourned.
Yes. Your name, sir?
AP Mahanti.
AP Mahanti.
You'll also item number
2. Name?
Manoranjan Sahoo.
M.R. Sahoo.
Item number 14, my lord. On behalf of
114.
on behalf of Manoranjan
Apanganash?
Vishwabhushan Mishra.
1.
Adjournment. But I think this 14 is a tied up matter. It cannot be listed before any other bench. But anyway, I understand you are seeking adjournment, but you must realize that
today.
this bench is not functioning regularly. Yes?
My lord, item 7.
7, what's your name, sir?
Sumanta Bhuya, your lordship.
Yes.
Your lordship, matter may be taken next week after your lordship.
Next week, sir, I cannot direct, sir. Because it's not my assignment. I cannot direct.
Then your lordship, any other day, your lordship.
Yes, yes. Adjourn with liberty to mention. You have to move again before
Yes,
the
sir.
assignment.
Yes, your lordship.
Item 10, man.
Yes.
Arjun.
Your name, sir?
Kirat Kumar Panire.
Yes. You could not obtain that instruction, Mr. Panigri.
Pardon, my lord?
This is coming for the second or third time. You could not obtain that instruction.
No, this is first time, man.
First time.
First time. 10th.
Yes.
Supplemental list.
You
Item 1.
mention, Mr. Sahu?
I have done.
Okay.
Item.
Item 1.
In spite of my colleague had mentioned this, the connected matter, that means of the wife, that is already there in the bench assent.
Okay. Mr. Mahanti, Senior Advocate, with Mr. Sahu, so S.K. Sahu, for the petitioner. It is submitted by the Senior Advocate that the connected writ petition
It is 21407 of
21407 of 2025 is before the assigned bench. Is before the regular assigned bench. So, according to the matter stands adjourned. The petitioner shall have liberty to move the assigned bench for listing of the matter. The regular assigned bench for listing. Item 1, Mr. P.K. Mahanti, is both P.K. Mahanti. The Senior Advocate, P.K. Mahanti is. Mr. M.R. Sahu for the petitioner, Mr. P.K. Mahanti AC for the opposite party. The Learned Counsel for the petitioner 6 and has adjournment. Stuff. Liberty to mention for listing before the assigned bench.
Item 3.
Petitioner none. Mr. P.K. Mahanti AC for the state. The matter is adjourned with liberty to the petitioner to move the assigned bench for listing.
Item 4,
Same, person number 4 same order. 4 Mr. Mahanti, 4 Mr. Devraj Mahanti. Petitioner none. None appears for the petitioner when the matter is called for the.
item 5,
So S.K. Nath for the petitioner, Mr. Devraj Mahanti for the state. The counsel for the petitioner 6 adjournment. 6 and has adjournment. Stop. Liberty to mention for listing before the assembly.
item 6,
Mr. A.P. Mahanti for the petitioner, Mr. Devraj Mahanti for the opposite party, same order. Petitioner, Planning Council for the petitioner 6 and has adjournment. Liberty to mention for listing before the assembly.
item 7,
So S. Bhuya for the petitioner, Mr. D. Mahanti, Devraj Mahanti, AGA for the state, same adjournment.
item 8,
Yes, please.
The residents of villages of Uttarakhand.
Yes.
So there has been illegal conversion of agricultural land into a non-agricultural purpose. That is
Under which provision? Which provision the conversion has been made?
under section 8A, conversion has been applied for. And
8A of
8A of Koiler.
Coiler Act. Yes.
Under group 12A. That there has been.
That order is not applicable or not? Then why you are coming to the court? You have to be actually like you are officer of the court. You must understand. Don't convert this court to the court of ADM, sub-collector, collector, secretary. We are exercising mandamus or certiorari at a much higher level.
This is a personal land. This is somebody's land who has converted his own land agricultural.
Well, then if you are not a party interested, then the statute says if anyone agreed by order, if the statute doesn't say so, then you can file a PIL, but not a writ before the assignment.
That is affected in this.
So why are you not filing appeal?
Because that is a personal conversion that has been done. We cannot go for appeal only because the land belongs to that person who has done the conversion.
How can you be impacted? How a third party? You see, ownership is well defined. The concept of ownership is well defined. The party who owns the land has the right to get it converted, and the authority is defined in Whaler Act. How a third party can have a say there?
There is a nine jury. We have a place mapping also. For your provision.
No. Don't hand up documents like this. Either it is part of the records where Mr. Bola is having that.
Yes, sir.
So if it is a PIL, then this is not the assignment also.
this is
So,
PIL.
No, you know.
obviously, I have to be a little subtle also, and I don't have to tell him that it's a PIL. Either you approach the authority, if you have a locus standi, if you do not have a locus standi, whether because non-jury cannot be converted. So they have not converted non-jury. See, this poking nose in others' affairs this is a classic case. If you are asked to these persons, it's in a lighter vein. Suppose you ask these persons to go to the border and guard the country, they will not go. But XYZ converting his land, you have a problem. You see, his land, how these ownership rights can be restricted, by which code, by which provision?
That is that area which has been converted.
You see the
Prairie space. The whole
you are yourself, your case, you are contradicting yourself. You are saying that it's a conversion of private land. Private land, if it is private land, it is converted, then there is some basis because he has ownership rights. How the ownership rights can be curtailed? By which provision of law? Have you read any eminent domain? Land Acquisition Act. The state can acquire. The ownership rights are curtailed completely because by state has power to exercise eminent domain. This is not a case of land acquisition. This is a personal right of enjoyment of property. It is a fundamental right guaranteed under Constitution. Your, whatever, why you will poke your nose?
That will cause, affect us with the more, rainwater will not drain up.
How do you say that you will allow the public rainwater to a private land? Have you read Reliance versus Fletcher? For what? Strict liability. What happened in Reliance versus Fletcher? Reliance versus Fletcher, what happened?
What is that first?
The water that's flowing in somebody's land, because it was dug up, so it got discolored. So even that is not that's a tortious claim, Reliance versus Fletcher. What you are saying is that you have no semblance of right even. And you are asking the REIT court to interfere in somebody's enjoyment of property guaranteed under Constitution.
There is contravention with the Rule 12.
Rule 12A contravention, then you have to file appeal. How a REIT court will adjudicate that? If you have a locus standi, you have to define your locus standi, establish it. And Mr. Bola also agrees with me that it's a PIL. We do not know. Even PIL cannot be a private interest litigation. And it's good that you are arguing on basis of the facts of the case. You have to keep it up. I mean, don't hesitate to argue the point, even if by perception you are thinking that it is against you. So you take your chance before the regular bench. Because in OLR matter, we cannot interfere in at the initial stage. It's a statutory authority was passed OLR. I'm sorry, this is item 8. Mr. Kanungo. So Devadatta Kanungo for the petitioner, Mr. Bola, JK Bola AGA for the opposite parties, Learned Counsel for the petitioner has adjournment as sought for. Stop. Liberty to move the assigned bench for listing of the matter. Yes.
9,
Yes, please. Petitioner none, Mr. Bola AGA for the opposite party. None appears for the petitioner when the matter is called. Stop. The matter stands adjourned. Petitioner has liberty to move the regular assigned bench for listing of the matter.
item 10,
Mr. Khirot Kumar Panigrahi for the petitioner, Mr. JK Bola AGA for the opposite party. Learned Counsel for the petitioner 6 and has adjournment. Stop. Liberty to mention for listing before the assigned bench.
11,
Mr. BK Sahoo for the petitioner. Yes, Mr. Sahoo.
Villages of Pura village matter. Case with the
PL.
change proceeding matter.
Sorry, sir.
Boundary change proceeding.
Boundary change proceeding of a village.
Village.
In between two villages.
Two villages.
Proceeding under?
One of the Orissa Sarkar Schedule Rules 1962.
So it is applicable. The problem is that you must also be concerned with the interest of the petitioner. The petitioner invoking REIT jurisdiction is nowhere. Rather, you should approach the proper authority so that a decision or the proceeding can proceed in a proper manner. Yes, Survey Settlement Act rules.
Direction of the High Court is ordering director as past order unexpected. That I am challenging. In contrast,
Survey Settlement Rules 62?
61.
61. 61 of the 62 rules.
61. What's the Survey Settlement Rules 19? That is a different matter.
Where is the order?
Unexpected matter. Page 25. On the relevant page 48 matter. I am challenging the order with 6/9/2025 matter. Part by the law the director. Survey director of land records and survey.
So this order is not applicable.
No matter.
Okay.
When I am challenging that order on the ground of matter, this order is
Okay, you take notice.
Convention of the order dated 4/2023 passed by this Honorable Court, Annexure 7 matter. Pursuant to order of the Annexure 7 matter, Annexure 7 matter. I know you have a glance to it. page 30 minor.
Yes,
Well, before going to the answer 7, kindly I submit my background of case minor.
but it's a case of re-adjudication, page 35, para 6. The court has directed,
Minor,
coordinate bench has directed for reconsideration.
minor. Part 6 minor.
Yes,
Minor. That's the contravention of this part minor. Well, but in the circumstance, this court interprets would the improved order at answer 8 set aside to same and they remind the matter to the director of land interest from survey and completion button for a re-adjudication of the matter dealing with specific demands of the petitioner's minor and finding the same on the authority deciding such matter to facilitate complete adjudication. This court, while directing the petitioners to appear before the competent authority on 42/2008, permitting them to bring their objection to the inquiry report at annexure 6 months. Hearing on the date of appearance itself, the competent authority is also directed to involve personal hearing at the time of hearing of the matter and bring an outcome in giving the merit disorder. My humble submission is for listener. Or specifically direct that to appear on the petitioners of the other villages matter. On who directed permitting them to bring their objection to the inquiry report at annexure 6. Only 7 the villagers of Raghunath only appear, no objection has been filed. We know where
if they do not file, what court will do? Please appreciate this. But the court says permitting them to bring. Them means the villagers, not the court. Suppose today I direct to file an objection. Mr. Bola doesn't file the objection. So what the court will do?
only
Anyway, you take notice because it is not applicable. I have to issue notice.
but no
The petitioners' villages are before this authority, are before this court for the second time or for the third. For the third time. For the third time.
minor.
Stop challenging the order passed by the lauded, passed by the Commissioner Land Records. Annexure 8, you are saying?
And it's a 10. Authority is 6925.
By the Director Land Records and Survey, Odisha. Comma, order dated 6/9/2025. It is submitted that the authority did not hear the affected parties as directed by the coordinate bench by order dated 2/2/2023, disposing of WPC number 15795 of 2018. Issue notice along with this order. Then Para. The learned AG, upon advance copy served, appears and waives notice on behalf of opposite parties 125, TO25. You require any extra copy, Mr. Bola?
No. You have already served the copy.
What was up?
Give another copy. Let one extra copy be served on Mr. In the office of the learned Advocate General. Issue notice to OP number 6 by SPW registered post with 3D. Requisites for issuance of notice shall be filed within 5 working days. 5 working days sufficient, Mr. Sahoo? 5 working days. List after yes, sir. A liberty to mention. What is the IA?
I am here for annexure 10.
Let them appear. IA 18904 of 2025, issue notice as above, fixing early returnable date, accept one set of process fee and postal requisites. Any action taken pursuant to the order impugned dated 6/9/2025 by the Director Land Records and Survey, Board of Revenue, Odisha, Kotak in BCP case number 9 of 1998. देखिए लिख देवे. shall be subject to result of the writ petition. Yes. Liberty to mention.
item 12,
If there is no course of action after the annexure 10.
What is the course of action you are apprehending? Where is that?
On annexure 10 manner. Directly the math of policy.
So that's not coercive action. So that is how we are passing orders that any action taken shall be subject to. Because you see, this has become a never-ending process. These writ applications are being filed since 2013. For the last 21 years, 2004. 21 years. So the High Court has stalled the entire thing. I mean, purposefully or otherwise, this should not have happened. This is a basic administrative determination of boundary of village is a basic administrative function. For 21 years, the High Court has time and again has
Clear violation of the order.
No, that's not clear violation.
But
The court directed the villager to file objection. So the villagers violated the court order, not the authority.
another thing, man. Another part, important.
You take notice. You take notice by speed post. So coercive action I cannot direct because this cannot be said administrative order to be a coercive action. So that is why I have said that any action taken shall be subject to result of the writ petition.
What kind of subject?
अच्छा, you want status quo?
My.
ता पूर्व कर दियो status quo regarding the boundary of the subject matter villages shall be maintained by all the parties, including the administrative and statutory authorities, till the next state of hearing.
item 12,
Petitioner none, Mr. S.B. Panda, AGA for the state. None appears for the petitioner when the matter is called. The matter is adjourned. Stop. Matter is adjourned. Petitioner shall have liberty to move the assigned bench for listing of the matter.
13,
May I please,
Mr. H. K. Sahoo for the petitioner.
may I please, Your Lordship? Under the petitioner, the impugned order is at answer 23, passed by the Commissioner, Land Records and Settlement Cuttack 1. In revision case number 172 of 2025 by exercising the power under section 15B of the Survey and Settlement.
It is not applicable.
It is not up.
So
It is a revisional order.
take notice.
No,
Mr.
what
K.
happened in this case, my Lord, the same order was challenged in another writ petition also. Because
No, that is pending in coordinate bench.
coordinate bench has already passed this order, my Lord.
So this has to go to that bench.
My
Because-
predicament is, my Lord, they are going to change the record of right. Change the record of right and
The coordinate bench did not
all
pass
steps.
interim order.
Again,
Coordinate bench did not
passed an interim order. Passed an interim order in respect of the other petitioners, my Lord. Because what happened in this case, yes,
But ideally, you should move the coordinate bench because
it will ultimately go to the, Your Lordship kindly give
the
that
order
protection.
is they are not listing. Once the matter gets listed here, they are not listing the matter again. So at least what you can do, you can move the coordinate bench. And this like today, I think one matter, the first matter, husband wife both are petitioners into two writ petitions, revenue matter.
Same order can be passed.
No,
Because it is.
I
same order has
understand.
been
I
passed.
understand. I can pass same order, but it will not be listed again before that bench. That's the problem. So how you are benefited?
No, it will be listed. Why? Because
I don't know why.
Because it
Why
is a
is
break
that?
bench, Your Lordship is entertaining, it will go to the coordinate bench. Not like that. Copy may be supplied to me.
Yes, you take this.
I have already served the copy.
Take copy out of the
Order copy.
order copy.
No, no. No. What happened is a peculiar case, as Sarpanch has filed a revision to take away the Stitivan right of the petitioners, which has been recorded long back. And the commissioner, by entertaining such revision, has
Here
directed.
no casualty is there.
Here no caveat. In that writ petition, the caveat is there.
The caveat is there.
No, here in this writ petition, caveat is not there.
There.
But it is reflected that caveat is
It is
there.
detected that caveat was with that writ petition, Miller. And along with that writ petition, this has been posted.
Then we have to hear the caveat.
That the caveat was in that writ petition, Miller, in which this order has been passed.
Correct, sir. Got
And
it,
the
got it.
caveator was heard in that petition.
Correct. So that is more the reason I have to hear the caveat. You see, when you, that is another difficulty. So in fact, I should mark that she is present. Manasya Mahapatra.
Yes.
In fact, that is how I asked you. the caveat.
Same caveat, Miller, in one writ
So
petition.
she has to be heard here also.
Your Lordship can see the list. But what is the?
No, without hearing the caveat, I cannot pass order. Without hearing the caveat,
Placed before the court.
it has to be.
Yes.
It is submitted by Mr. Learned Counsel, Mr. Sahoo, the Learned Counsel for the petitioner that coordinate bench has taken up the self-same issue as
30281 of 2000.
just self-same issue as how it is placed before the other bench. Because the revision application, the revision or revisional order passed by the
Asked by the Commissioner of Land Records,
Commissioner Land Records,
and
Liquid
Settlement.
Liquid to 179 there, see. Involves several plots and one of the persons affected has approached this court by filing WPC number 30281 of 2025,
In which
which was taken up by the coordinate bench, and orders have been passed. An order dated 27/10/2025 has been passed. Stop. Accordingly, the matter shall be listed before the assigned bench. Accordingly, the petitioner shall have liberty to move the assigned bench for listing of the matter.
Yes. But if I will,
Sorry, sir.
that, you also kindly observe that it may be placed before that like
No.
side. Otherwise, if I will move,
You have to move.
otherwise it will not be listed in normal course, Miller.
No.
Because I have to
You
move.
have the liberty, so at least that is a judicial order. Me directing the other bench to any matter, that's not a good thing. Today, same problem I have happened in division bench in another context.
No, if
So,
you register it,
You have pointed that why it is directed to be listed, placed rather.
okay, no.
Shall have liberty to move for listing before the assignment. Yes.
14,
Mr. Vishwabhushan Mishra on behalf of Manoranjan Mishra for the petitioner. Mr. S.B. Ponda AGA for the opposite party. Adjournment is sought for on behalf of the Learned Counsel for the petitioner. Accordingly, the matter is adjourned.
15,
Mr. Satpathy,
My lord.
Mr. Srinivas Satpathy for the petitioner, Mr. S.B. Ponda AGA for the
My lord,
opposite party.
in this case, the deity property has been taken away.
Last order, your lordship may see the defects were to be removed.
My lord, already I have filed and
Last order, your lordship.
my lord, I have
It should have been listed for fresh admission.
Yes, it should have been listed for fresh.
So, though notices, anyway, you please make your submissions.
my lord, the deity property has
So
been,
first of all, you show the improved order.
my lord, annexure 6, page 57 to 64.
Page 57. So this order is not applicable.
My lord, I am challenging applicable, no, my lord, no second appeal provision there.
No, it is up to you because on question of law, you have to assist me.
My lord,
You have to educate the court.
my lord. My lord,
The petitioner is agreed by the order dated orders passed in mutation appeal number 2/8/2023. Mutation appeal is under
under 42
of
mutation manual, read with
No, rule for
manual.
Rule 42.
Rule 42 of
Mutation manual.
the survey settlement rules. And 92 of mutation manual. Para 92. The rule is 42.
Then you have the book. Then that's a good thing because Odisha High Court is consistent nowadays that nobody should bring any book.
sorry, my lord.
No. I mean, this has become a pattern. 42A is revision, 43 is review. You look at it.
My lord, 42
Eighty eight ଅଛି
of the 42 appeal.
ଗୋଟିଏ ଗାଡି ଆମ ସମସ୍ତେ ମିଶିକି ସେଥିରେ ଆସୁଛି।
ସେଇଟା ନାହିଁ
42 is mutation. Issue manual.
yes sir
42
manual ଜାଣନ୍ତୁନି manual is a
instruction.
is a executive instruction don't go by manual it's a summary of that in fact that cannot go beyond the rules of the act also
My lord,
so look at 42A
42A. Revision.
ମତେ ଦିଅନ୍ତୁ
My lord. Revision.
this is order passed by the
Sub collector.
sub collector look at 42 dash capital F
ତ ବହିଟା ରଖିବା ପାଇଁ କହିଦେବ ତମ ସରିଗଲା ନେଇକି
My lord.
Vale.
My lord.
Please, the collector may of his own motion or otherwise
My lord.
otherwise is relevant for you
My
call for and examine records of any proceeding in which orders have been passed under rules 34 42 43
my lord.
42 is appeal Tahsildar or sub-collector as the case may be. Your case is sub-collector.
My lord.
In respect of any government land for the purpose of satisfying himself that the order was not passed under mistake of fact owing to any fraud, misrepresentation or account of material irregularity or of procedure and may pass such order thereon as he thinks proper. Any person considering himself agreed by any decision under this chapter may apply within 30 days from the date of decision for a review of the order to the officer who passed the said order. So how do you overcome this?
My lord.
As I was telling a young counsel that don't convert us to collector, sub-collector, tahsildar.
My lord, I will file revision. My lord, liberty may be given.
No difficulty. I mean,
My lord,
there is no limitation also. Mr. Nikhil, the Lord Counsel for the petitioner submits that the petitioner shall move the authority under the provision of Rule 42 capital A of the Odisha Surveys and Settlement Rules 1962 for effective redressal of his grievances as the petitioner is agreed by the order passed by the sub-collector under under Rule 42 of the Odisha Survey Settlement Rules 1962. Accordingly, the writ petition is disposed of. The petitioner shall have liberty to
30 days.
approach the statutory authority for redressal of his grievances in accordance with law. Yes, Mr. Pan, you said some.
43 ରେ 30 days limitation ଅଛି।
Say review ଚାହୁଁନାହାନ୍ତି। 42A ରେ revision. 40 say review, I don't think he will be satisfied with review. Review is before the same authority as you know.
एक्स्ट्राऑर्डिनरी पावर अछि 32 रे सर्वे सेटलमेंट एक्ट रे जोटी कोनोसी रिवीजन नाही अपील नाही किछि नाही गोटे एक्स्ट्राऑर्डिनरी पावर अछि
पावर भी अछि तापर एथिरे भी आपनकर द लैंग्वेज इज वेरी वाइड or otherwise for the purpose of satisfying himself that any such order was not passed under mistake of fact owing to any fraud, misrepresentation, material irregularity.
Lordship may kindly see 32 say that's for discussion sake 32 of Service Settlement Act. This is a very pertinent provision so far as
call for revision proceeding of revenue officers. This is Board of Revenue.
हाँ बोर्ड ऑफ नो कोठी जदि किछि नाही रिमेडियलेस हबनी सेही प्रोविजन टा से इन्वोक करि पारि
Odisha High Court decision is there, Justice DP Mahapatra decision. Basanta Manjari. What is that? That is how the Bhubaneswar cases were reopened.
Exactly.
Lordship referred to this provision actually.
Yes, Basanta Manjari.
नहीं Basanti Rani Jenna.
Basanti Rani. This is a very important.
But the problem is that thereafter, in another 25 years or something, or maybe another 30 years, all the cases the ADM reconsidered, they have come to High Court and everything has been set aside.
Back to square one.
Again, they have gone to the original authority. And some of them have gone to Supreme Court. Thank you, please. Bye-bye.